Hey, good morning, everyone. My name is Mike Longyear, and I'd like to welcome you to the Read Longyear, Malnati, Corwin, and Burnett webinar. We'll be touching on a variety of topics today. For those of you that aren't familiar with the firm, or those of you that are, Read Longyear is a general civil firm, which means that we do a variety of practice areas in the civil area, including trust and estate work, family law, employment, personal injury, small business, and real estate. We don't represent any publicly traded companies or governmental agencies. We work with individuals and families on their legal needs and services. Today, we're going to be covering a variety of topics, including the Washington State estate tax, the way that insurance coverage works in personal injury matters, as well as charitable giving. And also at the end, we'll be talking about the Swedish Death Cleaning. For those of you who have worked with us on trust and estate matters, you know that that's an important part of our practice in working with individuals and families on end-of-life decision-making and end-of-life planning, as well as trust and estate administration. So that topic will be sort of soft, if you will. It's not particularly legal-based, but it helps in the administration of estates when some of these issues are considered. Our speakers today are Joshua Reinertson on the Washington estate tax, Gregory Porter on the personal injury insurance coverage issue, Maria Gaydos on charitable estate planning, and Meng Che on the Swedish death cleaning. They will be each speaking approximately 12 minutes. You may have me jumping in to remind them to conclude their remarks, and I apologize for any interruptions, but we're trying to stay on a tight schedule today. And there will be a question and answer period at the end, and of course you're always welcome, invited to send us an email at info@readlongyearlaw.com with any questions, or contact any of us through our main number, office number 206-624-6271, or visit our website, readlongyearlaw.com, and contact any of us regarding any particular questions that you may have. So I may have jumped a little bit ahead of schedule with my comments, but again, welcome to our webinar. I'm Mike Longyear. I'll be here moderating with our speakers, Josh Reinertson, Gregory Porter, Maria Gaydos, and Meng Che. And I think we're going to let Josh start a couple minutes early. Josh, are you ready to go?
Yeah, that sounds good to me. Thanks for the introduction, Mike. Let me get my screen shared here. All right, there we go. So, good morning, everyone. So I'm going to talk to you today about the Washington estate tax, what it is, and some of the basic planning tools we use to address the tax. I only have about 12 minutes here, and this can be a very complex topic. So this will just be very high level overview. So Washington is one of only 12 states that impose a state level estate tax. So if you're a resident of Washington, which I presume most of you are, or if you're a non-resident, you own property in Washington, you'll likely want to know a little bit about the tax. There's also a separate federal estate tax, which we will not discuss, but that could be an important issue to address depending on the size of your estate. Okay, so jumping straight in here. So what exactly is the Washington estate tax? It's a tax imposed on the value of property transferred at death. That property includes virtually everything you have an ownership interest in. So bank accounts, investments, business interests, real estate, retirement accounts, personal property, and also the proceeds of life insurance policies. The value of the property subject to the tax is determined on the date of your death, and the tax rate that is imposed on the property starts at 10% and gradually increases to 20%. Who's subject to this tax? As I mentioned before, if you're a Washington resident, you're subject to the tax. If you own real estate outside of Washington, that will generally be excluded from taxation, but everything else you own will typically be included. If you are not a resident, you could still be subject to the tax if you own real estate or personal property that's located in Washington. Who pays this tax? It's the estate. This is not an inheritance tax where the beneficiary is responsible for paying the tax. It's the personal representative or executor of the estate that's responsible for filing the estate tax return, if it's required at all, and then paying any amount of tax due from the estate. When is the estate tax due? It's due 9 months after the date of death. There's also an automatic 6-month extension that can be filed for. And then what are the tax proceeds used for? The tax revenue goes towards educational expenses, including funds for reducing class sizes, teacher education programs, pre-kindergarten learning programs, before and after school programs, and also a variety of higher education programs. There are a number of deductions and exemptions that may be available to an estate, which will reduce the value of the estate that's subject to the tax. And the important ones are listed here. First, everyone has a $2,193,000 exclusion amount. So that first $2,193,000 of your estate is not subject to tax at all. Also, if your estate is under that amount, you don't even need to file a tax return. Second, any assets that are passing to a surviving spouse receive unlimited marital deduction, although that may be taxed when the survivor later dies. There's also dollar-for-dollar deductions available for distributions from the estate made to qualifying charities, expenses of administration, taxes, and then any debts that must be paid from the estate. There's also a couple other deductions available for farms and qualifying family-owned business interests, as long as those entities make up about 50% of the value of the estate. There's a couple of additional requirements that we want to touch on. So here's a very simple example of how a $3 million estate might be taxed. So Ted dies, unmarried, has $3 million of assets in his estate. He has a $200,000 mortgage on his residence, and he's leaving everything to his son under his will. So here you can see his total assets. His exclusion, his $2,193,000 exclusion is applied. He receives a deduction of $200,000 for the debt on his house that has to be paid, and then about $27,000 in administrative costs, taxes, and funeral expenses. That leaves $580,000 of his estate, which is subject to the tax. That falls under the 10% bracket, and his estate owes $58,000 to the state of Washington. Okay, so here are some of the common strategies, or let's say basic strategies for addressing the Washington estate tax. First is charitable gifting, whether that's during life or at death. Non-charitable gifting during life. And then for married couples, credit shelter trusts. And there's a variety of other planning tools available, but really too complex to address in this 12 minutes here. Okay, so charitable gifting. Really, there's two major options here. Charitable gifting during your lifetime or at death under your will. If you gift during your life, then you get the benefit of a deduction off your annual federal income tax return. The donated assets are removed from your estate, so they generally won't be subject to estate tax at death. But the downside with lifetime gifting, whether that's charitable or non-charitable, is that you will no longer have access to the donated assets during your life. So if you have increased expenses towards the end of your life, you may have less assets to address those expenses, which can create a problem. And then finally, if you make lifetime charitable gifts, you might have to file a federal gift tax return, although there's deductions available for gifts to charities, so typically there will be no tax deal. The second major option here is just leaving assets to charities under your will and making the gifts at death. The value of the assets going to qualifying charities at death get a deduction for estate tax purposes. The advantage here of giving at death is retaining the use of the assets during your life. You know, the big downside here is that you don't see your funds get put to work for your charitable causes, which can be a significant benefit for many people. Whether you're doing charitable gifting during life or at death, the key requirement is that the organization you're donating to must be a qualifying charity under the tax code. So 501c3s, churches, mosques, synagogues, governmental entities like parks or schools, those are all typically okay. Sometimes foreign charities receive a deduction as well, although that can be problematic during life. So that all needs to be verified if you are intending to take deductions. Okay, so jumping into non-charitable gifting here. These are gifts to any person or entity other than a charity. First, Washington doesn't have a gift tax, so the state doesn't care what you gift from your estate during life, and you don't need to file any state returns. However, the federal government does impose a gift tax. It's a 40% flat tax on the value of the gift made, but there's, again, some important exceptions here. First, outright gifts to a surviving spouse receive an unlimited marital deduction, so no, there's no federal gift tax due on that gift. In 2023, each person has a $17,000 annual exclusion for gifts, which means you can gift $17,000 per person per year to as many people as you want without reporting or paying tax on the gift to the federal government. So if you have 10 grandchildren, you can give them $170,000 each year. So this can be a simple and powerful tool for reducing the size of your estate. Third, any gifts over that $17,000 annual exclusion generally required to be reported to the IRS. However, at the federal level, each person has a $12,920,000 lifetime exemption from gifts. So unless you're making really large gifts, typically there's not going to be any tax due. That exemption amount is going to drop down to about $5 million adjusted for inflation starting in 2026. And then finally, you can also make direct payments to educational institutions and medical providers for qualifying tuition or medical care expenses. These payments can be made for anyone's benefit in an unlimited amount, but the key here is that the payment has to be made directly to the service provider for qualifying expenses. So for example, you can't give tuition money to a child and have the child pay the tuition. That would be considered a reportable gift. You want to pay that directly to the education institution. And then one issue I'll note here, which is very significant, is the concept of tax basis step up and the capital gain tax consequences for recipients of gifts. In very basic terms, when you gift an asset during life, the beneficiary receives the asset subject to any appreciation of the asset's value since you first acquired the asset. So if the recipient of an appreciated lifetime gift turns around and sells the asset, they may be paying capital gain taxes on appreciation of the asset that occurred while you owned the asset, not just the appreciation that occurred while the beneficiary owned the asset. In contrast, if you transfer an asset at death rather than at life, that asset gets what's called a tax basis step up, and the beneficiary would only pay capital gain tax on appreciation of the asset occurring after your death. So the point here is that you need to be careful about what assets are being gifted and consider and weigh the tax advantages of gifting during life versus gifting at death. And then finally, I want to touch on one important issue for married couples. This is particular to Washington State. And that's the loss of the $2,193,000 exclusion. So let's take a look at this example here, which is not unusual. Married couple has children. Joint estate is $3 million, so they each own $1.5 million of their joint estate. They have a typical estate plan. When one spouse dies, everything passes to the surviving spouse. When the survivor dies, everything passes to the children. And so what happens here is that the first step, the assets passing to the surviving spouse are eligible for an unlimited marital deduction, so there's no estate tax imposed. However, because of the marital deduction, The deceased spouse's $2,193,000 exclusion is unused, and under Washington law, that exemption does not transfer to the surviving spouse, it just disappears. So now the survivor ends up with an estate of $3 million. When the survivor dies, they only have their $2,193,000 credit to cover the transfer of the whole estate to the children. And in this case, that would be a tax bill of up to $80,000. So what's the solution here? That's inclusion of what's called a credit shelter trust, although there's a variety of names for this. But they have the basic characteristics listed on the slide. It's a trust that's formed under a will or revocable living trust of the deceased spouse and comes into existence only at their death. It's usually for the sole lifetime benefit of the surviving spouse. The trustee expends the funds in the trust for the surviving spouse's health, education, maintenance, and support needs. So it's a very, very broad standard with few limitations. Spouses can act as their own trustee. And then importantly, the assets held in the trust are excluded from the survivor's estate at death. And I'm running out of time here, so I'm going to jump to the last slide. And so this is what a more tax efficient plan might look like in this scenario. Husband has a credit shelter trust in his will for his wife's lifetime benefit. When husband dies, his will places the first $1 million of his $1.5 million share of the estate into the credit shelter trust for his wife's lifetime benefit. This transfer is shielded by his Washington exclusion amount. The remainder of the husband's estate of $500,000 can go outright to the wife, and that's not taxed because of the marital deduction. When the wife dies, she now has $2 million in her estate instead of the whole $3 million. The $1 million that was placed into the trust, including any appreciation over the wife's lifetime, passes to the children outside of the wife's estate and free of estate taxes. The $2 million in the wife's estate then passes to the children and is covered by her own $2,193,000 exemption. So the point of the credit shelter trust is to capture the first spouse's credit in order to, essentially up to double the credits available to a married couple. So I'm way over time here. In closing, this is a very brief introduction to a complex topic. Everyone's estate planning goals are different and the tax rules change from year to year. So it's really important to talk to your advisors and make sure that you have a plan in place that makes sense. And if you have any questions, my email address is down there at the bottom. So please feel free to email. Mike?
Great. Josh, that was great. And really important information for everyone to kind of think through and consider in planning their estates are the tax impact. And we're really talking about planning for that second estate, which can seem pretty distant, but it's important. Our next speaker is Greg Porter, and he's going to be talking about insurance in the personal injury context. And it's a pretty complex subject. So Greg, appreciate you doing this and sharing your expertise on this. So Greg.
Yes, thank you, Mike, and good morning, everyone. My name is Greg Porter. I'm a litigation associate attorney at Reed Longyear. And with my brief time, we're going to go on a bit of a frolic into a different subject. I'll be introducing you to the principles and framework for insurance coverage and subrogation for personal injuries in Washington, as part of my practice is personal injury litigation. Now, the first step to understand subrogation are the different types of insurance that might be available. First and foremost is the liability or third-party insurance. And this is the insurance held by the person at fault. And legally, they are responsible to pay. But they don't pay until the case is either settled or reduced to judgment. And that's a process that might involve lawyers like me and take months or years. So what do you do about the medical bills that are piling up for the treatment you need now? And that's where the other insurers and the whole concept of subrogation comes in. Because other insurers will pay without fault, more or less meaning upfront, and then obtain an interest in the ultimate settlement. And the first in line of all of these is personal injury protection or PIP insurance. In Washington, this is usually a component of your auto insurance policy, since in our automobile society, most injuries that are not covered by workers' compensation will occur in cars, and they pay medical bills upfront and seek reimbursement at the end. And the next type of insurance is uninsured or underinsured. And that combined is UIM. Now, this is also a type of insurance held by you, the injured party, but they sort of act like the liability insurer. Is a general case that happens is, let's say you have 100,000 or more in damages, but the party who hurt you only has $50,000 with which to pay you. So the party at fault pays the 50,000, and then you take the remainder of your claim to your own insurance, UIM, and you ask them to cover the deficit. And the UIM carrier will step into the shoes of the party that hurt you. So this is an adversarial proceedings. Sometimes you have to take your own insurer to court to enforce the UIM policy. But it is a component of Washington public policy that auto insurance must include UIM coverage. So it's another source of payment for your injuries. Now, another option is general purpose health insurance, whether from a spouse, your employer, or the state health insurance exchange. And this is not specific to personal injuries like PIP, but for our purposes, it acts like PIP, as they will pay bills upfront without fault and then have a subrogated interest at the end. The one caveat being that oftentimes, if they know you have PIP, they'll make sure that PIP pays first. And only after PIP has paid its policy limits will your general purpose health insurance take up the yoke. Another potential provider is Medicare or Medicaid, so the major government insurance programs. Now, by law, these are secondary payers, which means that any other insurance that can pay must pay first, whether that's PIP, whether that's your own health insurance, whether that's any other source of funds. And this is where we're going to get into subrogation, because even though they're the secondary payer by law, sometimes the way the chips fall, they are actually the first to pay. Say, a catastrophic injury, someone's in the hospital, and the hospital just bills Medicare, knowing the patient has Medicare coverage. So Medicare pays first, even though they're a secondary payer. So how do you work that out? And that's where we get to the whole concept of subrogation. This big word I've been using all along. What does it mean? I'll quote some of this rosy language from our Washington State Supreme Court. Subrogation is an equitable doctrine, the essential purpose of which is to provide for the proper allocation of payment responsibility. It seeks to impose ultimate responsibility for the wrong or loss on the party who in equity and good conscience ought to bear it. So how does that really work? Is the responsible party ultimately pays, but another insurer, whether that's Medicare, whether that's PIP, whether that's Regents through your work, pays up front and then seeks reimbursement. And this process has two steps. Step one being, does the insurer have the right of subrogation? And then second, if they pursue subrogation, what is that process? So turning to the first, the right of subrogation. And this right either comes from the contract, the insurance contract you signed, or is just a matter of equity based on Washington law. And virtually all insurance contracts in Washington that cover personal injuries are going to allow subrogation. I sort of just assume there's subrogation, because even if it's not in the contract, it's public policy in Washington that insurers have an equitable right of subrogation, including for personal injuries. And then for frameworks like Medicare and Medicaid, it's also baked into their laws, whether state law or federal law. And indeed, Medicare has a whole department dedicated to pursuing subrogation. Now, there is an exception to the right of subrogation, and that is the made whole rule, which basically says if you, the injured party, don't get fully compensated from the party that hurt you, the insurers don't get their full reimbursement, which I think makes total sense. Why should you have to pay them back in full if you, the person who got hurt, didn't even get paid back in full? And so you often see this in the case of uninsured or underinsured, is maybe even after UIM coverage is exhausted, there still might not be enough insurance coverage to pay all your bills. And so then the subrogated interests get wiped out. Or I've also been able to use this rule in negotiating with insurers for, say, a contested settlement is the defendant never admitted fault. Maybe there was a split in liability, so it was only a partial settlement. And then I'd say, well, Geico, my client didn't get paid back in full because the claim was contested, so you don't get the right to get paid back in full. And oftentimes that works. More money, more compensation for the actual injured person, which is always the goal here. Now, the mechanism of subrogation is by law, the insurer has a lien over the eventual judgment or settlement with the at-fault party. And so once settlement or judgment is received, then some money has to go back to satisfy that lien. But the insurer does not get dollar for dollar back. So take a typical case, there's PIP coverage of $10,000, and they pay all $10,000 to cover your medical bills after an injury. Do you have to pay them back $10,000 from the eventual settlement? No. In fact, you actually have to do math to determine the correct amount of subrogation that the insurer gets paid back. And each type of insurance will have its own equation, but we're looking at the equation for PIP insurance, since they're at the front of the line. So this is the one that comes up most often. So if we look at an example here, let's say it's a $20,000 total award for personal injury, maybe a traumatic brain injury, long-lasting, maybe lifetime effects, and then PIP insurance coverage of $10,000. And let's say attorney's fees were at a pretty typical contingent range of 1/3. So 1/3 of 200,000 is 66,600. And let's say attorney costs were about 3,000. Maybe an expert had to be hired. Maybe there were a couple of depositions. These costs might even be pretty low for a personal injury, but we can use them for illustrative purposes. So take the amount advanced by PIP, 10,000, and then subtract this sort of computation where you find out the percentage of the total award that PIP covered. So if the total award was 20,000 and PIP paid 10,000, that's equal to 5%. And so 5% times the total attorney's fees and costs gives you this number, 3,480 and change. And this is the amount that gets reduced from PIP's right to subrogation. So PIP gave you 10,000, and the amount you pay back is 6,516 and some change. So again, not dollar for dollar. And I understand for some attorneys, math sort of causes a fight or flight instinctual response. So what's really going on under the hood here is that PIP is pitching in for the attorney's fees. After all, you, the injured party, had to go get an attorney and fight the good fight in court. So it's only fair that they pitch in to cover some of the attorney's fees costs. And you run the math, it comes out to a little more than 1/3 gets deducted from the amount PIP gets paid back on their subrogated interest. Now, again, different types of insurance will have a different computation. Medicare especially is its whole own thing. There's the Center for Medicaid Services, or CMS, that has this really labyrinth algorithm to calculate the amount of subrogated interest they pay. I don't think the best scientific minds in the nation fully understand how it works, but in a personal injury case, it's something you'll negotiate with CMS to resolve. Now, with all these different insurers and all these different subrogated interests, as my goal as representing the injured party is to maximize recovery for my client and also minimize the headaches of going through this whole process. So this is a basic framework. It won't apply to every case because every case is unique, but this is sort of the basic framework for what insurer bills should go to first. And in my experience, if PIP is available, make sure that they're paid first until they're exhausted. As they're front of the line, they don't make a fuss. They cover bills, and as we just saw from the previous slide, they only get a fraction back of the amount that they pay. Next, I'd say is once PIP is exhausted, send medical bills to private health insurance because they're the most PIP-like out of all these different insurers. Again, they might require that PIP be exhausted, but once they take up the yoke, it's a very similar process, a very similar calculation. Next, if Medicaid is available, that's Apple Health in Washington, they get a statutory lien of reimbursement, but they're very easy to work with, in my experience. They're willing to cut a deal. They understand. So happy to work with them. And then finally is Medicare, because they get really robust federal laws for recovering their interests. Again, they have a whole department whose job is getting their reimbursement back. Now, sometimes it can't be helped, because you'll see situations where the hospital will just bill Medicare first thing, as they don't have my flashcards. But if that's the case, then what you do is, once there is a settlement or judgment, pay these liens back in the opposite order. So make sure that Medicare's interest is resolved first and foremost, because they have what we sometimes say in the business, a super lien over any interest. So it's really critical that they get paid back, then Medicaid, then private insurance, and then PIP at the end. So I think I'm running low on time here. So here's a little summary card for everything we've discussed. Who's legally responsible? In my estimation, under the basic framework, who should pay first? And then who, in my basic estimation, should get paid back first? Thank you all very much for your time.
Greg, that was excellent. And thank you so much for taking us through that very complicated process, and appreciate your expertise and experience with that. And for those listening into the webinar today, if you have had that experience of negotiating or being involved in a personal injury action, you know how complex it can be. So Greg, thank you again for that.
Of course.
Our next speaker is Maria Gaydos, and Maria joined the firm this year. So for some of you listening today, she's a new face, but we're excited to have her join us. She's a graduate of the University of Hawaii School of Law and has been practicing in Seattle for the last, 6 years or so, and practices in the estate and trust area, particularly on litigation, but also on the planning and probate trust administration side. And today, I think one of her favorite topics, and that I got to co-present with her on, is charitable planning and giving. So Maria, you want to take it away?
I'm just getting my slideshow going. Just 1 second. Thank you for your patience. All right, can everybody see that?
Yes, Maria.
Okay, so like Mike mentioned, I'm primarily a litigator. My passion with estate planning is charitable giving. And I think it's a really great and creative way to offset estate tax liability and feel good about it. So why gift? It feels good. You can support your favorite causes. You get either an income tax or an estate tax deduction, which Josh spoke to you about. And when to gift is really, we only want to talk about and go into charitable gifting if you're charitably inclined. If minimizing taxation is your sole goal when it comes to strategic estate planning, there's other ways to do it, but this is a good hybrid way to structure your estate in such a way that you're supporting something you care about and also amassing tax deductions. But you can always pass more to your children without making charitable deductions. So that really brings up who is charitably inclined, and the demographic is changing. A lot more people are choosing not to have children, or to have children later, or fewer children, and have greater assets to spend on their families and friends, and maybe more than what they need. And that's where charity comes in. So high net worth individuals, people without children, and people who prefer that their children not inherit at all and maybe have to work a little. So gift timing, I won't hinge on this too long. Like Josh mentioned, there's different ways you can structure the gift timing. Your lifetime gifts, which you get an income tax deduction, but you no longer have that money to use if you need it. And then bequests, where you don't get the benefit of seeing your money put to use, but you also have it if you need it. The types of gifts are really interesting, and I think that's really important when speaking to clients. They might not always realize that what they have is valuable to other people, especially collections. So So the simple gifts are cash gifts. I'll deal with those. So complex gifts, gifts from retirement accounts, which can be a whole entire webinar, but I'll touch on those. And then there's just your belongings, your artwork, maybe you're an author or a creative person, and you have other things to offer in addition to your financial assets. So the practicability of these gifts is an issue, because while they are interesting, and there's all kinds of organizations out there that would love to keep and curate your assets that are not money, it comes with a cost. So can a charity really use your gift? And we work with our clients to make sure that that's a possibility, and if not, to consider liquidation. Retirement accounts. So retirement accounts this is a special way to charitably gift during your lifetime that many people may not be aware of, but if you're over the age of 72, there are required mandatory distributions from your IRS. The IRS allows you to donate up to $100,000 per year to charitable entities, as long as they meet the definitions under IRC 170 for what is a charitable organization that can receive tax deductions. And then as a beneficiary, the charity doesn't pay income taxes. And also, you may not want those deductions. So if the required mandatory distribution puts you into a tax bracket where you're paying more than what you want to, in your lifetime, you can use the benefits of your mandatory distributions from your IRA accounts to make charitable gifts. So it's a two-way street, and it's a benefit for both the account holder and the charity. Other vessels for charitable giving are foundations and donor advised funds. And these are generally not advised for most clients, but the foundations are, but the DAFs aren't. So we'll talk about those. So if a client wants a current tax deduction, but you want to retain your rights to direct where the money goes, there's different ways to do this. You can set up a private foundation or a donor advised fund. And the donor advised funds are very straightforward. There's all kinds of donor advised funds out there, managed by all different entities. And it's pretty easy. You just donate the money and you express your intent for the donation. But like you say, it's a donor advised fund. The DAF isn't required to distribute the money how you like, but most DAFs generally do follow your charitable intent. Foundations are more complex, and they really come from a different intent when you're talking about charitable purpose, which I feel that foundations are important for people who have a very specific desire and a strong want to leave a legacy and a significant amount of assets, because there's so much administrative setup that goes into creating a foundation, and also setting up a board to manage the foundation, and the question of what might happen to your foundation when you pass, and making sure that you have just a really strong framework to comply with your IRS rules and to continue the foundation into the future. So why would you use a foundation? Like I said, not very often, but if you want to maintain control and operate the foundation, if you want to employ children in your foundation, but there are certain restrictions for that, but that falls into your legacy, and maybe also providing for your children if you're not necessarily leaving them your assets, but you're leaving them maybe a livelihood, and you like this idea of being remembered or having a very specific cause or ethos that you're trying to create. Another way to structure charitable giving is through charitable trusts. So there are several types of charitable trusts, and they are called split interest trusts. So we have charitable remainder trusts, charitable lead trusts. We call charitable remainder trusts CRATs and CRUTs and CLATs. So there's a lot of acronyms out there. And really, it comes down to working with your client and seeing exactly what they want to do and what kind of tax benefit they're trying to create from setting up these trusts. So the CRAT has mandatory annual payments of a specific amount to a non-charity beneficiary. And you set it up for a term of life, or a term of years. And the remainder has to be at least some percentage of the initial fair market value. A CRUT is a child remainder unit trust. Again, it's very similar, but there's mandatory annual payments of a percentage of each trust asset to a non-charitable beneficiary. And the things about CRATs and CRUTs is you have to establish the payments in the beginning when you set up the trust, and you have to sort of work very closely with CPA and a financial planner and look at the assets, because you can't change the mandatory payments once you've established the percentages. A charitable lead trust is also a split interest trust. So it's a guaranteed annuity interest. You get a specific dollar amount versus a unit trust, which is a specific percentage. And that's determinable and paid annually for a term of years. But for a lead trust, if it's for life, it must be for the life of a spouse, a lineal descendant, or a lineal descendant of a remainder beneficiary. Qualified conservation contributions are very interesting, and there's so much I could say about them. I think these are particularly interesting for people who have large amounts of property, maybe farmers or landowners who don't need to pass that on to future generations. Especially with farms, if your next generation is interested in farming and the value of the assets of the farm are going to drive your estate into a bracket where you don't want to be, and you can't necessarily qualify for farm tax deductions, which are very complicated and usually have a long list of requirements. Making conservation contributions give you charitable deductions for permanent easements on value. And the other interesting thing about conservation contributions is you can divide the land interest and the mineral interest. So, and this is a subject for future research that I find really fascinating, because I wonder how that applies to water rights, especially in Eastern Washington, where that's quite a valuable asset itself. And if you can divide the two, you can maybe create wealth as well. So I'm having a little bit of trouble with my slides because a bunch of them aren't showing up. I'm going to go back in time. Because I really want to talk about selecting the right charities and how we work on charitable contributions. Okay, so my slides aren't working, so I'm just going to go ahead and talk to you about it. So like I said, it's really interesting to think about what we can help our clients with in terms of non-cash assets. So that's artwork, collections, maybe literature, and we want to make sure that we work with the charity to receive the asset in a manner in which they can accept it. So this is called the free pony problem, which is that a client has a valuable piece of artwork and you want to donate it to a museum, for example. The donation is great. You can make sure that it aligns with the museum's intent and purpose, but really it is a free pony. Who's going to pay for the storage and maybe the restoration of the artwork? Who is going to continue supporting this artwork? And that
we may have lost Maria there. So, but in the interest of time, we'll jump into our next topic. And first I want to thank Maria. That was informative and super interesting, and definitely something for all of us to consider in terms of legacy and the charitable needs in our community. Our next speaker is Meng Che, and Meng joined us during the pandemic, so some of you may not have met him. He is a graduate of Seattle U Law School and also has an LLM from the University of Washington Law School. He will be working primarily with our trust and estate group, but practices in related tax areas. But today, Meng is going to be talking with us about the Swedish death cleaning process. And as I mentioned earlier, this is such a important topic. It's not necessarily legal per se, but certainly in estate and trust administration, we deal with the consequences when there hasn't been a consideration about personal property and its disposition. So I'm going to let Meng get started. Meng. Meng, you're muted.
Oh, sorry, Mike. Thank you very much for confirming that. Can you also confirm that you can see my slides? Okay. All right. Thank you everyone for joining today. I do appreciate you taking the time to join Read Longyear summer webinar and partake in the information that we're able to share with you today. As Mike mentioned, my name is Meng Yu Che, and I'll be speaking on the non-legal topic of Swedish death cleaning. With my legal practice focused on estate planning and probate matters, I'm always looking for new ideas and best practices to share that can help potential clients and partners have a more productive estate planning or efficient probate experience. Furthermore, in the past year, working with clients, I've received numerous feedback from multiple clients about how tough settling a loved one's estate can be. Thus, I wanted to share the concept of Swedish death cleaning, which not really a legal concept or topic. It's very important because I think that it can really alleviate some of the emotional suffering and or pain that loved ones can feel after someone's passed. And it can be a useful tool for everyone, not only to proactively plan for, but provide that peace of mind that nothing important is left unclear or undecided after your passing. Okay, so what is Swedish death cleaning? Death cleaning is actually based on the Swedish concept of, and I'm going to potentially butcher the pronunciation here, dostaning, which literally translates to death cleaning, and was popularized by the 2018 New York Times best-selling book titled The Gentle Art of Swedish Death Cleaning by Margareta Magnusson. And it centers on accepting that we will all eventually die, and that by gently and gradually decluttering our lives beforehand, we can alleviate excess physical and emotional burdens on those we leave behind and who may be already grieving over our loss. There's also a separate streaming show on the Peacock network as well, which I believe started airing in April of this year. So if anybody is interested in seeing death cleaning in action, definitely please check that out on the Peacock network. Now, while death cleaning is linked to minimalism and its decluttering effects is similar to that achieved by the Marie Kondo KonMari method, the focus is very different, as we are not evaluating each item on whether it brings us joy. Rather, there's much more objective and pragmatic criteria that are utilized that we will touch on shortly. So why should someone try death cleaning? Some key benefits of gentle and gradual efforts to thoughtfully evaluate, plan, and potentially redistribute our possessions before we pass can save our friends, relatives, and executor from having to physically sort, clean, donate, and discard items after our passing. This can also save estate administration costs, as contracting with a professional estate sale company to do very similar work usually starts at about $5,000 and can quickly escalate from there to potentially $15,000 to $20,000, depending upon the amount of property that needs to be worked through. Also, another thing that people are unaware of is that an executor can charge a reasonable fee for their time and effort as well. So there's additional costs on top of that as well for someone that's administering an estate. Next, Swedish Death Cleaning can also provide one last meaningful opportunity to appreciate each object before releasing it to others and allowing that object to have a second life with someone else rather than remaining stored and unappreciated until our death. Some of you who've watched Toy Story 3 at the very end, kind of seeing, the toys get a second life with another child. That's a great example of the benefit that I'm talking about here. Next, Death Cleaning can enable us to make more thoughtful decisions about who should receive specific items rather than leaving it up to an executor or family members who may be experiencing or undergoing complex emotions after we're gone, in which case, if emotions are running high and people, are still dealing with the stages of grief, they may not want to sit there and let go of certain items, or they may want to try to obtain more items just to kind of have that connection with someone that they've recently lost. And finally, and most importantly, doing so can provide moments for meaningful conversations and reconnections over shared items, not only with those currently in our lives, but others that may have grown distant or estranged over time, which has become a much more prevalent fact and experience in recent years. And especially in my estate planning practice, the topic has come up much more frequently in terms of people kind of sharing the fact that they do have more estranged family members that they've kind of lost touch with for a myriad number of reasons, besides, just moving away or having different beliefs or opinions. So when should someone start death cleaning? While it's not age dependent, the author in the book did sit there and suggest that it's generally suggested for people over age 50, but it can be practiced by anyone when they begin accumulating a lot of stuff in their lives. Also, individuals who may be downsizing their living arrangements or moving to another location, such as empty nesters or retirees, or people who are looking to relocate with remote work opportunities. This is a great opportunity to implement death cleaning as well. Another situation that's come up in the past is also like if you just find that you're storing other people's items that are not your own property for a long time. A lot of siblings, myself included, or for friends who decide to, go travel for X amount of time, they may ask a sibling or friend to kind of store their stuff. Sometimes they say it's temporary. However, it's amazing how long it can turn into a much longer time frame than what we initially were told. So this is a great opportunity as well to leverage death cleaning, as well as, if you're maintaining a costly storage unit. Where there's a lot of items that sit unused regularly. And additionally, if a person has become a custodian for unique family heirlooms over time, keepsakes or other inherited property that do not serve a useful purpose in that person's life, death cleaning can be used to pare down such items as well. So how do you start Swedish death cleaning? Well, the author in her book suggested beginning with non-sentimental items first that are easy to donate, recycle, or dump, or otherwise discard. This will allow you to build momentum before tackling thornier or more emotionally charged items. And next also is to consider regifting items that you no longer value or use, but that you received previously that were well-intentioned gifts, but you may feel guilty about discarding. So finding a new home for them by gifting them to someone else who may be able to leverage them or use them going forward is a great way to continue the person who the original intent of such items. Also, people should start slowly, targeting one room or area a week and kind of fitting it into their own schedule. This should not be like a summer cleaning effort where it's just like one day or one weekend, we're just going to tear through the entire garage. You know, kind of starting slowly will enable people to not lose focus, because if you're dealing with especially emotionally charged items, it can take some time to really kind of work through it all. And so kind of keep in mind that this is a marathon process rather than a sprint. The ideal goal of Swedish Death Cleaning is to kind of make this an ongoing process in one's life, not just a one and done type of process or event. Now, for more sentimental or valuable items that a person may not want to keep, or that they do want to keep and hold on to until they're passing, but they want to ensure that it goes to a good home. The author had a great suggestion about, as people are coming over to visit, or if you've segregated and identified things that you don't want anymore, to kind of put them in a separate room, and then request family and friends to come by and choose or reserve items, through a labeling system or whatnot, so they can select items they may want after you pass, or potentially to receive now if you're ready to part with it. This not only prevents hurt feelings and provides you the ability to choose if there is a disagreement, ensuring there are no misunderstandings after you're gone, but it also gives your family and friends the agency and choice to accept or decline items they may or may not want, but you may think that they should receive. Next, and this is actually one of the items that has come up in my practice, has been the fact that this is a great suggestion, is allowing family and friends the opportunity to review and request copies of pictures, because usually pictures or other media keepsakes, there's only one copy of. And so allowing people the opportunity to review such items and request copies be made before you pass is a great opportunity to not only allow these individuals to select for themselves and actually give them that opportunity to say, I want that or I don't want that. But then also, like, if you're bringing these types of photos out, especially at family gatherings, it allows everyone to kind of reconnect as well, to kind of say, hey, remember when this happened, or we were at this wedding, or when this photo was taken. And then the great thing is the next generation is usually present, in which case then you can kind of share those experiences with them as well, and kind of walk them through and show them those photos as well. So it's a great opportunity to not only kind of share those moments with people, but then also to sit there and democratize, these types of assets that, there's usually only one copy of. And, I've heard people talk about how, if there's a fire in their home, one of the first things that they would grab is the family photo album. So, you can imagine, after someone's passed, this can lead to a lot of infighting in the family as to who's going to get the photo album. And a final recommendation for any personal items or mementos that you may cherish and that you don't want to leave, but you don't think anyone would want, is to potentially keep them in a small keepsake box that's a little bit more manageable. The author actually recommended labeling it as "throw away after I die." So it's very clear that after your death, it should be tossed, and that there's no obligation from the executor or any of your family members or friends to hold on to such items after you're gone. These could be things that only have special meaning to you, such as ticket stubs, programs, other types of those mementos that no one else will have any context for. And last, as a reminder, if you're having difficulties with any items, try to be objective. Ask yourself some very pragmatic questions when you're evaluating objects, such as, when was the last time you used an item? Does it serve a purpose in your life right now? And would it be burdensome to your family or executor to deal with later? In closing, I want to recommend trying Swedish Death Cleaning and to help with decluttering our possessions before eventual passing. If any attendees are members of the King County Library System, there are a number of copies available for borrowing. And not only is this book a very quick read, the book also contains a lot more practical advice and heartfelt stories from the author that I could not include due to our limited time here today. With that, I thank you all for your time and attention, and would like to transition the webinar back to Mike to begin the question and answer session. Thank you.
Ming, thank you so much. And you're inspiring to deal with some of my personal stuff, certainly. As you comment, we all accumulate, and what may have meaning for us may not have meaning for those receiving our estate, and certainly the charitable issues that Maria touched on too, on the care and support of those things, applies to family members as well. So we do have some time for Q&A. I'm not seeing any particular questions, but everyone is welcome, of course, to email us either directly or through the website to answer questions that you may have about any of the presentations or follow-up matters. And again, we appreciate you attending today. The webinar will be posted on the website in the next week, and our other webinars on other topics are there as well. Again, invite you to contact any of us with any questions, and thank you all for attending. And unless one of our speakers has another comment that we need to touch on, you think we've kind of covered our bases for today? Okay, all right, well, thank you all. Okay, bye. Bye-bye.